Hello class, and welcome to another video as part of our video lectures included in our American History 2 course, an undergraduate survey of American history from Reconstruction to the present. Today we are looking at the Reconstruction Amendments. By this point we will have looked a little at Reconstruction, and today we will put a special focus on the 14th Amendment, the 13th, 14th, and 15th Amendments being the Reconstruction Amendments. We have read and discussed a little about Reconstruction. I would like to read to you the definition used by Reconstruction era National Historical Park, part of the U.S. National Park Service. They list Reconstruction as lasting from 1861 to 1900 and call it the historic period in which the United States grappled with the question of how to integrate millions of newly freed African Americans into social, political, and labor systems. And they list it as being a time of significant transformation in the United States. So let's jump right in. 13th Amendment says, Section 1 in whole says, neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States, or any place subject to their jurisdiction. And generally speaking, the 13th Amendment ended slavery in the United States. The 14th Amendment, there are 5 sections, and we will look at each of them rather quickly, but some in more detail than others. So Section 1, I know that at this point we have, as assigned reading, looked at the language of Amendments 13, 14, and 15, but I will read some short sections, quotes, from each amendment and discuss it in a little detail. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Now that language, in part, did away with the Dred Scott case. It set aside the Dred Scott case. It took both race and slavery out of the determination of both U.S. and state citizenship. It clarified to some extent the idea of birthright citizenship in the United States, which does have some exceptions. Our courts have excluded the children of diplomats, the children born in the United States as part of certain Indian tribes who were outside, at least partially outside, the control of the United States. And if we were to be invaded, if there was an invasion of the United States, children who were born to the invaders would also not be considered citizens of the United States. All right, Section 1 still, but a different part. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So states cannot stop, cannot end, cannot abridge, shorten the privileges or immunities of citizens of the United States. Well, what does that mean? Well, that's up to the courts. So what have the courts said? The courts have clarified that the privileges or immunities are only those privileges or immunities that exist between U.S. citizens and the national government. So a state cannot abridge something that is a privilege or immunity that binds a citizen, so one of us, to the U.S. government, the U.S. national government. These would include constitutional protections or laws that pertain to all U.S. citizens. Some things that through court cases have been specifically listed. This is certainly not an exhaustive list, but the right to pass freely from one state to another state, the right to petition Congress for a redress of our grievances, the right to vote for national officers, the right to enter public land of the United States, and the right to inform the United States authorities of a violation of U.S. law, and the right to carry on interstate commerce. All right, continuing Section 1 of the 14th Amendment, nor shall any state deprive any person of life, liberty, or property without due process of law. So, prior to the 14th Amendment, there were no restrictions on individual states set by the Bill of Rights. The Bill of Rights only put limitations on the U.S. government, not the individual states. But after the 14th Amendment, the courts began to apply what we call incorporation against the states, which had limited applications of the Bill of Rights to both state and local governments. If courts determine that anything is a right, privilege, or immunity across all U.S. citizens, then states cannot abridge it, and that includes passing of state laws. For example, 1947, Adamson v. California, Fifth Amendment protection against self-incrimination was applied to state courts in addition to the U.S. courts. So that is an example of incorporation. But incorporation, as I said, is not straightforward. It does not automatically include the entire Bill of Rights, only what the courts have specifically included. Something that wasn't included in 1884, Hurtado v. California, the Fifth Amendment right to a grand jury was not incorporated. It was not pushed down to the states. All right, continuing the 14th Amendment, Section 1, nor deny to any person within its jurisdiction the equal protection of the laws. Equal protection of the laws. Equal protection here often means not segregated out to a specific subgroup in any way. The Supreme Court noted in Korematsu v. United States that laws targeting a single ethnic racial group were, quote, immediately suspect and in need of rigid scrutiny. But the use of classification in general, it does not render a law void. Classifications by race are not automatically going to cause a law to not pass scrutiny, but they are going to cause it to be scrutinized more heavily. In striking down a Virginia ban on interracial marriage in 1967, the Supreme Court noted that racial classifications might be allowed in other circumstances and even specified preserving order in a jail system if a state passes laws meant to help a particular racial group or to remedy a discrimination. The courts say that that still requires those laws to undergo strict scrutiny because it is separating out a group. Continuing, we have Section 1 with applications in more modern times that are not as directly related to the Reconstruction era, and we may look at those in more detail later, but I want to mention them now while we're talking about the 14th Amendment. The 14th Amendment in more modern years has been used to either allow or not allow restrictions on abortion funding, medical treatments, and physician-assisted death. These things coming from an amendment that was clearly one of the three Reconstruction Amendments and meant to help the United States to reintegrate or to fully integrate the recently freed population. So it will be interesting as we move forward and look at some of the more modern applications of the 14th Amendment. So, the 14th Amendment has 5 sections, and that was by far the longest section for us to look at, Section 1. Let's move on to Section 2. In Section 2, we see that from it, we get changes in how we are counting our population. The census counts for congressional representation must include all persons excluding Indians not taxed. So here we see another special exclusion of our Native American population, and that is in part because they were not really considered under the full control of the United States. But that is, though interesting, not something we'll go into detail with here. So any state, a state in the North or the South, that limited voting rights based on race would have its representation in Congress reduced by effectively reducing its population numbers by the number of people that it had restricted through racial restrictions in voting rights. This is because there were many northern states, in addition to the southern states, that had restrictions on voting that were by racial classification. This was seen as somewhat of a compromise. All right, Section 3 of the 14th Amendment. We see that the United States and state office holders who engaged in insurrection or rebellion, generally speaking, those who participated in the Confederacy, were then not allowed to run for office in the United States or in any state. This restriction was attempted to be used against former President Trump, but the Supreme Court in Trump v. Anderson in March 2024 decided that states could not enforce Section 3 of the 14th Amendment against candidates or federal office holders. Section 4 of 5 of the 14th Amendment declared that the U.S. public debt was unquestionably legal and declared that Confederate debt or losses due to the emancipation of slaves owned by an American, those debts were void and they were not to be paid. Section 5 of the 14th Amendment specified that Congress had the power to enforce the 14th Amendment by passing laws. A partial list of the laws passed included the Civil Rights Act of 1866, which we will look at in a little detail, the Enforcement Act of 1817, the Ku Klux Klan Act of 1871, the Civil Rights Act of 1875, another one we will look at in class some, the Slave Kidnapping Act of 1866, and the Peonage Abolition Act of 1867. Peonage is the act of using peons for labor, and a peon, as used there, means a worker who is being held in a state of servitude in order to work off a debt. So, the 14th Amendment had some interesting ratification requirements. Related to it is the first Reconstruction Act of 1867, which did a number of things. It created, it turned the South into 5 military districts and put generals in control of those districts. But Section 5 of that law required that in order to seat members in Congress again, a rebel state had to ratify the 14th Amendment as a condition to fully rejoin the Union and have its members of Congress seated. And that is a very interesting twist that we will discuss more in class. The idea that states that were only partially considered states were required to ratify a constitutional amendment in order to be accepted back fully into the fold of the United States. All right, so finally, the 15th Amendment of our 13, 14, 15 Reconstruction trio says, the right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of race, color, or previous condition of servitude. And that language, in no uncertain terms, specified that the race of an American citizen could not be used to determine whether that person could vote. And that ended the need for the constant step up from 13th Amendment to 14th Amendment to 15th Amendment. And that ends our discussion on the Reconstruction Amendments, and I look forward to continuing our discussions on them in class. Thank you.